Now, Wali Shah, who is said to have fired the shot that killed Allah Dad, is a fugitive from justice and has not been so far arrested. This is the observation of the Privy Council, and it has observed that Allah Dad has not been, Wali Shah has not been arrested. Mahbub Shah was arrested. He was arrested and he was convicted of attempted murder of Hamidullah Khan and sentenced to 7 years rigorous imprisonment for that. Because Mahbub Shah had fired on Hamidullah was injured, but this was taken to be an attempt of murder. He was punished accordingly. So far so good, very simple. But now comes the invoking of section 34. Mahbub Shah was also tried for murder of Allah Dad, and he was convicted of this murder under section 302, read with section 34, and he was sentenced to death by the sessions judge. Section 34 has been invoked. It has been invoked against Mahbub Shah. He was convicted for the murder of Allah Dad, which was actually caused by the other person, Wali Shah. High Court confirmed this death sentence, and we will see the arguments given by the High Court. High Court says, as soon as Wali Shah and Mahbub Shah ran to the assistant of Qasim Shah, they fired simultaneously in the direction of complainants. Complainant means Allah Dad and Hamidullah Khan. They fired simultaneously in the direction of Allah Dad and Hamidullah Khan. The court says it is difficult to believe that when they fired the shots, they did not have the common intention of killing one or more of the complainant party. And if so, which means if they had the common intention, then both of them are guilty of murder, notwithstanding the fact that the fatal shot was fired by only one of them. So the court has come to the conclusion that there was a common intention. And according to the High Court, a common intention to commit the crime came into being when appellant, that is Mahbub Shah, and Wali Shah fired the shots. It was not there earlier. The common intention came into being on the spot when they fired the shots. The Privy Council did not agree with these conclusions of the High Court, and they reversed the judgment. And now we will see what arguments are taken by the Privy Council. This is what the court writes in its judgment. Their lordships means the lordships of the Privy Council. Their lordships are prepared to accept. So the Privy Council has accepted these two things. Mahbub Shah and Wali Shah had the same intention. Now mind the difference. The High Court was using the expression common intention. The Privy Council is using the expression same intention. And as I pointed out earlier, there is a whole lot of difference between these two expressions. If there was common intention, section 34 will become applicable. If there was no common intention but only the same intention, then section 34 is not applicable. That makes the whole difference. So the Privy Council observes Mahbub Shah and Wali Shah had the same intention. What was the intention? The intention to rescue Qasim Shah, if need be, by using guns. The intention to rescue Qasim Shah. And in carrying out this intention, Mahbub Shah picked up Hamidullah for dealing with him, and Wali Shah picked up the deceased, that is Allah Dad. Then the court asks, where is the evidence of common intention to commit the criminal act? And here, which is the criminal act? Killing of Allah Dad. The whole question before the court is only this first act of killing of Allah Dad, not the second act of injuring Hamidullah. So we are concerned with the criminal act of killing Allah Dad. The court asks, where is the evidence of common intention to commit the criminal act? And then comes the answer. evidence falls far short of showing that Mahbub Shah and Wali Shah ever entered into a premeditated concert. The court says that there was no premeditated concert to bring about the murder of Allah Dad in carrying out their intention of rescuing Qasim Shah. Yes, there was an intention to rescue Qasim Shah, but there was no premeditated concert to bring about the death of Allah Dad. This is the conclusion arrived at by the Privy Council, and once this conclusion is there, then obviously the result is quite clear. This is the decision. Their lordships are not satisfied that Mahbub Shah was rightly convicted of the offence of murder under section 302 read with section 34. So this whole case hinged on the fact whether there was common intention or not. The High Court arrived at the conclusion that there was common intention which was formed on the spot. The Privy Council says that there was no common intention even though there may be same intention. And since same intention is not covered by section 34, therefore section 34 is not applicable and Mahbub Shah cannot be convicted of the offence of murder under section 302. We have gone through the judgment of the Privy Council. We will now see one different angle of the same case on the same facts. Let us come back to the statutory provision of section 34. Three things are required as we saw earlier. There must be a criminal act. It must be done by several persons. And the criminal act must have been done in furtherance of the common intention of all these persons. Now, in this case, in Mahbub Shah versus Emperor, what is the criminal act which is being considered by the Privy Council? It is the criminal act of causing death of Allah Dad. There is no doubt about it. This is the criminal act. The criminal act of killing Allah Dad. Is this act done by several persons, or rather was this act done by several persons? There is a clear answer. It was done by only one person. Let us see the facts again. Wali Shah fired at Allah Dad, who fell down dead. Mahbub Shah fired at Hamidullah, causing injuries to him. In this case, in fact, there are two criminal acts. The first criminal act is killing of Allah Dad. The second criminal act is injuring Hamidullah. We are not concerned about the second act, injuring of Hamidullah. For that, Mahbub Shah has been punished and that point is not in appeal. We are concerned here only with the first criminal act. The first criminal act was killing of Allah Dad, and very clearly it was Wali Shah who fired at Allah Dad. Mahbub Shah had nothing to do with that act. Even if he had the intention of killing Wali Shah, alright, even if we presume that fact or assume that fact without agreeing, but the criminal act must have been done by several persons. Intention will come later. I am again showing you the bare provision. The criminal act must have been done by several persons. That is the first requirement. Then only we will see what intention was there, whether there was same intention, common intention. The intention part will come later. First, factually, objectively, the criminal act must have been done by more than one person. In this case, this criminal act of killing of Allah Dad was not done by several persons. It was done by only one person. That one person is Wali Shah. Mahbub Shah also did a criminal act, and that criminal act was injuring Hamidullah. As far as killing of Allah Dad is concerned, it was done only by Wali Shah. Since it was done by only one person, section 34 is not at all applicable from the very beginning. There is no question of looking into the fact whether common intention was there or not there, because the very first ingredient, criminal act having been done by several persons, is not satisfied. When a criminal act is done only by one person, there is no question of invoking section 34 against that person who was with him but he was doing some other criminal act. These two persons were together, but they were engaged in two different criminal acts. They were not doing the same criminal act. And therefore, there was no occasion for invoking section 34. In this case, the criminal act was not done by several persons. It is clear that this important aspect of this important case was not considered by any of the courts, neither by the Sessions Court, nor by the High Court, nor by the Privy Council. But we as serious students of law cannot afford to miss such a vital point. And that is why I have spent some substantial time on this important aspect of this case.